Hello, everybody, and welcome to episode 39 of Estate Planning TV. I'm your host, Christopher Small, and this is the internet's most passionate show about estate planning. What is going on, everybody? Folks, it is, I don't know when you're going to listen to this, but I can tell you I am super pumped. It is in March, early March, and spring is beginning to peak out for us here in Seattle. And it's a fantastic time. The winters are brutal. You know this because you're probably listening to this around here. But man, it's dark. It's rainy. It's cold, and all that's starting to change. So I'm pretty pumped. I'm pretty excited, and I'm also pretty excited to be here today to talk to you about the give and take of estate planning. And this episode is really kind of inspired by a conversation I had with a potential client earlier this week, and I kind of wanted to just give you the rundown and sort of show you how doing one thing can affect you in someplace else, and the sort of the benefits and consequences of making different decisions when it comes to estate planning decisions. There is, I always tell people when they come in, I tell my clients this, I tell everybody this, there really is no right or wrong answer when it comes to estate planning. The only thing that's right is what you want for your family, right? My goal is to make sure that you make informed decisions, though, when it comes to your plans, to your legacy, to your wealth, to your tax strategies, to make sure that you don't pick something because you think it's right, and then there are these unintended consequences over here that sort of jump up and bite you after the fact, after you can't change anything. So, to give you a little bit of background, this potential client was a married couple. They have an estate that's about $20 million. Okay, they're a little older, and they are thinking about how to plan for taxes. Okay, now one significant difference about this particular potential client from a lot of you potentially is they are not Washington residents. Okay, so they don't necessarily have to worry about Washington estate taxes. If you are not a Washington resident, you could have estate tax liability here in Washington, but it would be limited to the property that's located in Washington, which means sort of real estate for the most part. Bank accounts and things like that are really going to just reside in the state that you reside in. So those wouldn't be counted in that calculation. So if they were in, but the conversation that we had is still similar to what we're talking about now, although they have more options. All right, I know I'm kind of jumping around here. You'll see where I'm going here in a minute, but I wanted to sort of set the table to just give you an idea of what they've got. Okay, so let's give the Washington State rundown on what they might want to do here at the beginning and sort of the benefits and consequences of each, right? So at $20 million, you are going to be looking at estate tax liability for Washington State estate taxes at $2.193 million for each person, right? When spouse 1 dies, they can give everything to spouse 2 with no estate tax due at that time. But when spouse number 2 dies, they are going to pay tax on everything over $2.193 million. Okay, so you are looking at a tax burden of, I'm not good that my math is not that fast, but you're looking at 10% on the first million, right? Over 2, and then 14%, 15, 16, 17, 18, 19, 20. Okay, 20% capped. After that once you get to $10 million, basically you're at $20 million total. So from 10 to 20, you're going to be paying $2 million in taxes. Everything else below that, you're going to end up paying about probably another 1.5, we'll say. So $3.5 million estate tax liability in Washington State. One of the first things that you can do is you can create a simple trust structure that at least carves out the Washington State estate tax exemption for the first spouse to die. That'll knock off only about $150,000 or so, because you can basically double your estate tax exemption from 2.193 to 4.36. Okay. Now, I'm sure I'm going too fast for you. I talk fast. I'm going fast. If you're not feeling my flow here, do me a favor, hit the pause button, go get a sheet of paper, rewind it, and then just start taking notes on what I say. I think it'll all become clear. Okay? Each person gets their own 2.193. You can't give your 2.193 to your spouse. So if you die with no trust, no estate tax planning at all, when spouse 2 dies, you pay tax on everything over 2.193. Got it? Perfect. Now, one of the cool things about, no, I guess it's not cool. It's interesting. One of the interesting things about Washington State is that they have an estate tax, but they don't have a gift tax. All right? And that, with the new tax law changes that just happened, increasing the federal limit to $11.2 million per person with portability, makes things kind of interesting. Because in this scenario, let's say that, in a perfect world, right, what you could do is, potentially, you would have, so let's just continue on this tangent. By the way, if you couldn't tell, I spitball these things, okay? I'm sort of shooting from the hip. I know what I want to say, but I'm jumping around because I'm not scripted, and I think it's better that way. And it's less boring, hopefully. So one of the things that you could do is you could gift away a certain amount of your assets to get down to that $2 or $4 million range. You could, the first spouse would have to give some away. Well, actually, no. You could use portability, right? To when the first spouse died, the second spouse to die would have $22.4 million before they had to pay federal estate taxes. Okay, so basically, you could gift everything down to that $4 million, and you could pay no Washington State estate taxes at that time. All right, so that's one thing to think about. Now, there is a downside to that potentially. When one of the cool things about transferring assets after death is that you get what's called a step up in basis. That means that the person receiving the asset gets to take it at the present day value, and then they only pay tax on any growth that occurs after you've passed away. If you gift something to someone, that step up in basis doesn't happen. The person that gets the gift takes the asset at the original valuation, which means you could end up paying significant capital gains taxes down the road. I'll give you an example to demonstrate. 2 examples. Well, no, 1 example will work. Okay, let's say that you bought a house back in like 1990 for $100,000. Okay, so 100 grand is going to be your tax basis for that asset. Okay, if you own it and it matures at 2018 right now, you sell it today, it's worth $2 million. Okay, you are going to have to calculate and figure out what kind of taxes you're going to pay on that $1.9 million of growth. Okay, now don't worry about what the actual tax is, but just know that on that growth you could potentially have to pay some tax. Now, if you die and you give this house to someone, whoever it is, they get to take that house at a $2 million tax basis, which means when they sell the property, if they would sell it for $2 million, they would pay 0 capital gains tax. 0. That's kind of nice. If you gift, you lose that step up in basis. Okay? So there's sort of some math often that happens to figure out, okay, if I gift, am I saving more, even knowing that we're going to have to pay some capital gains tax over what we may have to pay in potential estate taxes down the road, right? And so there's just some math involved. But that is one of the differences. And that's what happens. Often people give away their home to their kids because they are trying to do a whole bunch of crazy stuff, and they end up losing that step up in basis, and they don't even realize it until it's too late. Okay? So that is one sort of tactic that you could take, and it would be a good one, right? The other thing that you could do is this trust plan. With this trust planning, you could one of the cool things that happens when the first spouse passes away is you get to decide what assets go sort of into that trust that creates that $2.1 million. And you can put the kind of assets in there that you want that will give you the right kind of growth and the right kind of appreciation, knowing that you get that step up in basis there. And you can keep everything over here and begin to gift it away slowly, or do whatever you need to do to sort of work things out, okay? When it comes to step up in basis and gifting, it's just important to understand that the math involved is going to really determine what you want to do and how you want to do it, right? And it's really important to understand that losing that step up in basis is often okay at a savings of something else, particularly if you have assets that you're not going to want to give up. So to give you an example, one of the things that we talked about doing with this particular client was taking some of these assets, putting them into an irrevocable trust, which means the assets are moved out of their estate, okay? They're gifted out, right? But you choose assets that you want to either hold on to for a long time, that are spinning off income of some kind, that will just continue to grow, knowing that you're going to have to pay tax on it someday, but the benefits outweigh the consequences of doing that. Okay, so you reduce your tax liability, you still have the income that's spun off there, you still have the assets that are saved for the family in the future, and then you can sort of just continue to go on and have the best of both worlds. One of the other things to think about, by the way, and one of the reasons that this was such a hot topic for us, was that I reminded them that there's the potential that in 2026, all these tax changes could be rolled back, right? So because of their age and where they're at in life, they have some wiggle room. They have less volatility to worry about when it comes to taking these assets out of their estate and sort of losing control and access to the assets themselves over time. So what they can do is they want to preserve their gift, their gift tax exemption now, so that if it's rolled back in 2026, if they haven't given anything away and it goes back down to $1 million, for example, now they're in big trouble, right? Because they have problems with what they're going to do with all this money. They're going to be facing some significant tax obligations. Age plays a role in this because once you give your assets away and put them in an irrevocable trust, it's difficult, if not impossible, to actually get those assets back if you want them. Okay, so that again, give, take, right? You can give and even get some income back, but if you need them back, it's tough. So you can get some estate tax benefit, but you have some access consequences. All right, so hopefully that wasn't too jumbled. I know I went fast. I'm a fast talker, and I kind of jump around, but I think the important lesson here is whether you have a $20 million estate or a $250,000 estate, it's really just important to understand and know the benefits and the consequences of the decisions that you're making, so that you can make informed decisions with the way that you want to do your estate planning, to make sure that you get to live a good life while you're here, and you can leave what you want at the end without having to pay taxes or give your money away to people that you don't care about. All right, so that is it. If you have questions, comments, thoughts, if you want to critique my video style, that's fine too. Leave a comment below. And you can email me, chris@cmslawfirm.com. You can call me, 206-659-1512. I would love to talk to you if you have questions about your own estate planning. Obviously, I'd love the opportunity to see if we might be a good fit, if I could help you. Otherwise, keep listening, keep watching, and appreciate you and your time. I hope these are helpful, and that's it. So I will, oh, you know what? Let's do this. I have got also, if you're listening to the end, by the way, congratulations. We're like at 15 minutes, and I really, really appreciate your time and attention. I've got I've got an email newsletter that I send out every week. It's called The Estate Planning Edge, and it's filled with estate planning tips. It's filled with strategies, but it's also filled with Sometimes I talk about legacy and I talk about sort of the mindset of money and things like that. So if you're interested in checking that out, I would love to talk to you too. So you can just go to cmslawfirm.com/newsletter, enter your name and email address, and you can get access to my thoughts on estate planning, legacy, generational wealth, life, money, success, happiness, family, everything, every week. So hope to see you there, and hope to see you back here next week. See ya.